Welcome back. This is Newsfile. It's your most authoritative news analysis show. My guest in the studio, Yao Pong, Dr. Eric Oduro-Osai, Dr. Gideon Boako, and Alhaji Yusuf Seni, MP. Now, we are going to deal with the Ameri matters that have come up, $510 million, so we understand, and the issues that are coming up as far as that one is concerned, and the motion for recession filed in Parliament, which saw the minority walk out of the House and accuse the Speaker of running a church or a home. Yeah. Now, a couple of your messages more on the toll levy. Sofo Yamusa in Kumbungu says that it will be politically suicidal for the NADO-led government to allow the implementation of this towing levy policy. Michael Amening in the UK says that this controversial towing levy is a very laudable policy initiative that when it is implemented in Ghana, it will help in reducing avoidable road accidents. But if majority of Ghanaians are resisting its implementation, I urge President Akufo-Addo and the government to listen to the citizenry and halt it for the time being so that the NPP government will continue to enjoy the goodwill and sympathy of Ghanaians. An issue that Dr. Oduro-Osai raised about the political cost of going ahead with this project. Now, let's come to matters regarding the alternative power that we sought to bring into the country through the previous administration sought to bring into the country, particularly when we're faced with Dumso now becoming such a big matter. And the minority in Parliament staged a walkout protesting the Speaker's decision to refer a motion for recession of the $510 million Ameri power deal to the Mines and Energy Committee for consideration. They had a number of issues to raise. Let's listen to this. We'll continue with the discussion in the studio.
See, we keep talking about the gagging. People don't understand because you see, it is not for nothing that the minority leader stands. It is because the minority have reasons to speak. And if you do everything to prevent them from speaking, you make the House very difficult to govern. For the first time, let's go and check Order 53. It is the majority leader who gets up with the indulgence of the Mr. Speaker and the House to vary the business of the day. You don't have the Speaker himself running the House as if it's a small church or his small home where he decides which business he calls. It's not done that way. The Standing Order 53 clearly stipulates which business should be done first, which one should be done second, and in that order. So if for any reason the leader of government business thinks that because of one priority or the other, they want to disorder it and do it in a different way, it is the leader in consultation with his colleagues on the majority side who agree, and then he will apply to the Speaker to get that done. But unfortunately, just look at what we are seeing. You see, we don't want it to look as if we are just complaining and complaining and complaining. But one thing we can assure Mr. Speaker is that we shall continue to fight until he understands that this is a house that every member must be given space. You were there when we were debating the Gate-Mo 2. Are you really happy the way he was conducting things? No. Members get up. You participate in the debate. Speaker does not participate in the debate. He was participating in the debate. Such an important thing. He said he was going to allow only 2 people to speak. We decided that fine, we want 2 people to speak, let them have the space. Even when a member, Honorable Mama Yaga, was reminding him that this is the only platform that ordinary citizens of this country can express themselves without being held, he will not bite.
We have taken this action to protest against the conduct of the Speaker in referring a motion to a committee of Parliament, a motion which have not been debated and a motion for which no decision have been taken. This is a House governed by procedure in a house governed by rules and the standing orders. Nowhere, and I challenge you to peruse the standing orders and give us basis and justification for the referral. We had initially signaled that we wanted to raise a constitutional objection to the motion, referring to a Supreme Court ruling in the matter of Ndebugri versus the Attorney General, and two others, where it was decided by the Supreme Court, even though on a matter relating to natural resources, that once Parliament gives approval, the matter now is in the realm of the judiciary once there is a contract in force, and that the matter is in the realm of the executive. More importantly, even as I was on my feet and I referred to the Ndebugri versus the Attorney General and two others, he did not allow me to refer to the particular quote. He only responded to a point of order by the Honorable K.T Hammond and again went into his bizarre conclusion on the matter. Under the circumstance, we have no option than to protest the manner in which he is endangering parliamentary democracy and its practice. The other day, it was about questions, and I'm challenging the Ghanaian public and the media and persons who are familiar with parliamentary work and the Hansard to go into the records. Everywhere, the minority must have its say, not its way.
It was most unfortunate because we're dealing with procedure. And what happened was that the Honorable K.T Hammond had moved the motion. The motion had been seconded. Don't forget that for whatever reason, our colleagues wanted, even before the motion was moved, they wanted to scuttle it. But we had our way based on the rules of procedure. Because I said to my colleague, the minority leader, that if a motion has not been moved and seconded, there's nothing before us. So what are you arresting when there's nothing before us anyway? Then he realized that he had made a mistake, sat down. The motion got moved. It was seconded. And then the speaker then ruled. In fact, before the member who was moving the motion could expatiate on the motion, the speaker said, "I've heard you. We're talking about misrepresentation, which has caused this House to take a decision. That's a very weighty issue. And that being the case, I don't want you to proceed. So whatever you have as evidence, take it to the committee. And if you take it to the committee, it will provide an opportunity for the minister to come with his own counter arguments or maybe documents to support you or not to support you. And then the committee will be helped to come to...
We also, as a minority, want to caution that this parliament does not proceed so that tomorrow any member of parliament can go and pick a contractual agreement and bring it here and say rescind.
On 2nd March 2017,
Right, so you heard MPs, particularly from the minority, shouting away, Ameri away, when the matter came up in the House. And earlier you heard Muntaka Mubarak, who is the minority chief whip, and then Honorable Haruna Idrisu, who is the minority leader. And then you heard also Oseiche Mensah-Bonsu, the majority leader, who had a different view of what they were complaining about as far as the speaker is concerned. Honorable Yunus Afseni.
Yes, thank you.
Are these complaints justified?
They are even more than justified. I mean, where do we have a minority in a dictatorship? You don't have a minority in a dictatorship. It's only in the democracy that you have a minority. And so they must have their say. It's simple. Unless, of course, we are not practicing a democracy. And that's why when you have a loop-sided parliament, it affects the work of a parliamentary practice everywhere. I mean, so clearly, the Speaker's conduct has come of late into, some scrutiny. And the first time I raised the issue on the floor of the House was when we had voted, voice votes. And the Speaker had ruled that when we were doing the voice vote, he had so motu by himself, counted the number of people, and he had come to the conclusion that the people on the majority side were more than the people on the minority side. The Speaker has no such authority. He's a presiding, the Speaker is an exalted presiding officer of Parliament. That's why Parliament, the rules say he must not take part in the debate. But what do we say? The Speaker constantly, I mean, maybe because he was a...
Let's deal with the issue.
Maybe because he was a member of Parliament. Was the
motion by procedure, was the motion supposed to be debated before it gets to the committee, or it is when the committee has done its work that you guys will have the opportunity to debate?
Again, Samson, you're a lawyer, and there are 4 lawyers here. What was the motion seeking to do? To rescind the decision of Parliament by an individual member of Parliament. The first question you must ask, is such a motion admissible in Parliament? That's the first question you should ask as a lawyer. When a state act has been constituted, can an individual member of Parliament set that state act apart? That's the question you should ask. Parliament was virtually functus officio in that matter.
Functus officio, meaning what?
Meaning they had concluded the discussion and arrived at a conclusion, and they had nothing to do with that unless a new matter was introduced by the executive. After all, they brought it to Parliament for us to reconsider the Ameri deal. That was it. But so the motion was admitted. Misrepresentation is a question of fact. It's not a question of law. Not so. So you must adduce evidence to show misrepresentation.
Okay, so he has explained to you why he's bringing the motion for rescission, and his reason is that.
So if there is misrepresentation,
his reason is that. Explain to our viewers and listeners.
His reason is that there was misrepresentation, and he didn't move the motion, but he says that there were certain facts that clearly were not known to him and the members of the committee at the time that they approved of the report, the report, and brought it to Parliament for us to vote on and approve the Ameri deal. That's what he's saying. And I'm saying that if misrepresentation,
and now those facts have come to his attention, and he wants Parliament to change its decision.
Well, I'm saying that if misrepresentation goes to the substance of the deal, it's not in Parliament that you must determine its effect. It is in the law court. Was it a mere representation?
Parliament has approved something.
Yes.
And those who were involved in the approval, one of them subsequently, almost a year after, comes back to say, now I have information that suggests to me that I may have been misled. Or because I didn't have this information, I helped to approve this business. Today, because of this information available to me, I am coming to the House to ask that let's put this thing aside.
So what prevents him from being a citizen?
And you say he can't do that?
What prevents him from being a citizen and not a spectator? Go to court, adduce the representation, state the grounds on which you seek to set aside, and be a dutiful and responsible citizen of this country. And say that this country must not be visited with additional costs. I'm saying so because I have insider information. I was part of the committee. What will be more weightier than setting a dangerous precedent where anybody relying on his own idiosyncrasies files a motion in Parliament to set aside an act of Parliament? That is not done. That is clearly not done. And that is why.
So the speaker was deliberate in not allowing you the opportunity to say that the motion, first of all, was
that was the second
inadmissible?
deliberate act. The first deliberate act by the speaker was admitting the motion in the first place. That was the first deliberate act, because the speaker ought to have rejected the admission of the motion, because it's setting Parliament on a dangerous footing.
How?
Something you don't see it. This government is entering into agreements, and they will enter into more, and they have the power to do so. They have a large majority in Parliament. It took them less than 48 hours to amend the Local Government Act. They will vote if the committee comes to the bizarre and weird conclusion that in their view, the agreement was tainted by misrepresentation. They will vote and they will win the vote. Pray that we don't have a lopsided Parliament in future. Many of the acts of state
will be reversed.
Will be reversed. And then you will introduce uncertainty and a danger to predictability in matters of contracting in this country. That's what we're saying. So let the act, that's why do we have separation of powers in the first place? Why did Montesquieu labor night and day to talk about separation of powers? He says, look, the executive has power to enter into treaties. But those treaties cannot bind us until we, the people, agree on those treaties. But Montesquieu was well aware that Parliament can be constituted by a larger, a more than disproportionate group of a people belonging to the same political party. He says, look, so when such happens, and we the people feel hard done by the sheer number of people in Parliament voting in a certain way which can lead to absurdity, we go to court.
You are saying that he didn't come under any rules of the orders of Parliament?
No rule or order of Parliament allows anybody in Parliament to set aside a decision of Parliament. No rule.
Are there rules of Parliament or law generally that allow Parliament to rescind its decision?
There are rules, because Parliament does not bind its successor. There are rules. And it's fundamental, you know.
Okay, so what you're saying is that,
what I'm saying is
because this was an act done by the previous Parliament,
yes,
you should not have a bite at it.
No, it means that it cannot bind us, but there's a way to unbind ourselves.
Court.
You either go to court, or the executive will introduce a new motion or bill, okay, to show clearly that what we did in the previous Parliament was wrong.
In that case, the danger of precedent you are talking about does not exist, because if an individual cannot do this, but the government can do it as cabinet,
the danger of precedent exists in the sense of the allocation of responsibility. The government, executive, now looking at the responsibility it has to manage the affairs of this country in such a way as to protect the public purse, can come and say, look, we've looked at this thing. So it becomes an executive act. It becomes the obligation, and the fallouts belong to the executive, not the individual. What they have done, in future, if the matter goes to court, the executive will say, well, we didn't do anything. I mean, just one of your members of Parliament who decided to reverse the deal. And now,
and you hold on, Doc. From what he's saying, provided that is what it is, do you find that it warranted the near verbal abuse of the speaker?
Absolutely not. And when he was explaining, I was asking myself, so if the minister responsible for energy or power had submitted same, who may be a certain parliamentarian, had made same submission of motion, would it have been any different? You know, I think that when he was explaining the thing, I was asking myself, is it about an issue of the capacity of the person or the MP submitting the motion, or is it about the misrepresentation But if it's about the misrepresentation, all of us know that misrepresentation can be innocent or fraudulent. And if it is innocent, it is voidable. But then if it is fraudulent, it avoids the contract. So the question then is, if indeed it is a misrepresentation, we have not yet established whether it is innocent or fraudulent. Why don't we allow it to go through it, the motions, if indeed we think that there is something wrong with it? But I think that it really should not have warranted the near verbal attack that emerged out of the process. They could have handled it in a way that could have led to a very good conclusion. I am of the view that Parliament are masters of their own rules. These things should not have even come into the public domain. You'd have had a way of managing it so that if it is a very good precedent we are setting, we set the precedent well. But I think because of the way the Ameri deal was couched, and because of the way it transits from one government to the other, we are looking at the political aspect of the Ameri deal than the substance. And that is what we should not do as a nation. I think that both the minority and majority should sit and have a way of resolving this issue. I also believe that parliamentarians should also see themselves as representing the people from their constituencies, not representing their political parties. Parliamentarians get to parliament and some of the decisions they take, I have the feeling that they represent they see themselves as representing their political party than the people they represent. I was asking myself that if any of the parliamentarians that walked out of parliament had walked out or they walked out, is that how the people they represent would have wanted them or would have wished that they behave? So in our whole parliamentary democracy, we need a complete overhaul. But I think that this is an issue that can be resolved. It's an internal matter. We should find a way of resolving it. If it has to do with amending the parliamentary procedures, we should just amend it.
Walking out of parliament is not new, is it?
It's not news. It's not new. But how and what would cause you to walk out is what we should manage.
They say they were being stifled, that they felt that they needed to be given the opportunity at least to be heard, that let the minority have their say and let the majority have their way. So at least let them have their say, you have your way.
I have a problem with that principle. Minority can have their say, majority should have their way. It shouldn't happen like that. It can happen elsewhere. At least we can learn from the United States of America. When it comes to issues of substance and objectivity, let us put politics aside. So I think that we should also look at the parliamentary procedures. In case a minority group feels threatened, feels they are being stifled, which other way can they go around the issue rather than walking out? Because when you walk out, you deny representation for the majority of the people you represent in parliament, which for me, it defeats the purpose of democracy. More to the point, you never consulted your constituencies before you walked out. And that, in that case, you are affecting, or what you are doing is undermining representative democracy.
They don't consult their constituents before they vote.
They don't.
They have a presumption that sometimes they understand,
But that presumption is rebuttable. Prior ratification. So I think we should look at all of that.
They are sponsored by parties. They are sponsored by parties.
Your constituents actually call you to ask you, why are you still sitting in parliament?
They are sponsored by parties, and they believe that they get their votes from their party
but
people.
But do they represent the parties or they represent us?
They represent the constituents.
So the constituent must influence their decision, and not the political parties.
They call us.
Right. And not the political party. That I have a problem with.
They could march to parliament and...
yes, together with assembly members. They go there and their voting pattern, their decisions and everything.
But do you feel that the attempt to stop the majority in their tracks, is it majority or even, they don't really see it as majority,
it's but
K.T Hammond, okay, to stop them in their tracks, was influenced by the fears that they now have, that so far we know that three of their members are facing questioning by the police. Their homes have been raided over the Ameri deal, over this new, fact, which has revealed a misrepresentation we do not know yet. But of course, this happened, and before this, there was a special committee, the Addison Committee, set up to review the whole thing, which came to the conclusion that the thing was tainted with fraud and that they needed to go renegotiate it or they will take some other steps. So they feel that there's a bias already and that this is intended to just do ill to their members.
I do not. I do not think so. I think that it's an issue of law. It's an issue of procedure. It's an issue of precedent. It's not. Insofar as they've not raised it at this stage, in all the playback you played, none of them raised that issue. It may be the undertone, but I believe that it's an issue of law, it's an issue of precedent, it's an issue of procedures, and we should respect that views of theirs. I think that whatever we do, whichever way we look at it, let us think into the future. If the current administration really wants to come after them, they have a way of coming after them. They have a way of coming after them. So I think that that should not be the issue.
Okay. Now, let's hear Dr. Gideon Brako. Now, and before that, can you clarify something for us, Honorable Minister Hussaini? When it is back from the committee, aren't you able to achieve what you seek when the report is back? It's been given to the committee, the Mines and Energy Committee. When they finish their work and bring it back to Parliament, there will be a debate, correct?
But the Speaker has not, before even the referendum, there ought to be a debate.
No, we have moved beyond that. My question is, when it comes back, there will be a debate,
Actions, right? Things take their color from their surrounding. It's cut debate to refer to committee. What justification, reassurance is there that when it comes back from this thing, there will be a debate?
I'm talking about procedure. What's the procedure?
Yeah.
After a committee
has considered... The procedure in the first place is that when the motion is filed,
we have moved on. We have moved on. After a matter has been put before a committee, when they bring their report, it is subject to the debate of the House, correct?
You see, when you fall down, when you hit your leg against the stone, when you hit your leg against the stone, to know why you have fallen, you must look at where you hit your leg.
I understand that, but I just want us to make progress on the questioning of procedure. The procedure is that when it comes back, it will be for debate.
I'm not able to tell because the Speaker's conduct has been
What is the normal thing? Yeah. That's what I mean. What's the standard?
The normal thing is that the report is presented, is debated. Sometimes, just recent OSP, the Office of Special Prosecutor,
right?
Because we had arrived at the conclusion and they wanted to know it, they asked the chairman to speak to it.
Right.
Then the next day they took
the
report.
You have confirmed that it will be brought back for debate.
For debate.
When it is brought for debate, will you participate?
Well, will it be debated at all?
If it's brought back for debate,
you don't know.
Will you participate?
I don't think that we have speculative jurisdiction on this table. So, what is happening is that Doctor said some very important thing, and it is important that we state that yes, innocent or fraudulent misrepresentation must be decided not by Parliament. That's why we are saying that for us, there is a better way to deal with it. I agree with you, better way. And that better way is to let that person take the matter.
That point you have made, yes.
Yeah, so substance is a matter of parliamentarians, but of course we need to add our voice to it.
I've heard you on it.
Yeah,
I think viewers deserve your non-parliamentary view, which is also very informed.
And then the street lawyer view as well. You see, listening to Honorable Hussaini and the minority, there appears to be what they think is bias on the side of the Speaker. And that's quite harrowing, that you get members of Parliament who consistently would want to, quote unquote, put the Speaker in a certain bad position. I see it as an attempt to intimidate the Speaker.
This is news to you?
It's not news, so to speak, but you see, we need to put things in their right perspectives and then analyze them based on the specific issues at hand. And so what is the argument being adduced in this particular case? I've heard the minority talk about the fact that, because of the general consensus on the fact that the minority should have their say and the majority should have their way, which I think is not an official position of Parliament, and I don't believe in that. I believe that parliamentary debate must conform to superior arguments. And so the issue of minority should have their say and the majority should have their way doesn't come in at all. The Speaker exercises his
If you don't hear the inferior argument, you can't determine the superior argument.
Of course, but the arguments must come from both sides. Right. But we shouldn't put it in such a way that, let us speak and let them have their way. That is not what the law requires us to do. So the Speaker we are talking about here is not an amateur person in the chair that he sits in. He's been a former member of Parliament before. The Speaker is also an astute lawyer. He's been a diplomat, a high commissioner before. So he's a politician. He understands the game and the rules of engagement in the House.
He's an author. He's been teaching politics for all his life.
In the House of Parliament. So no one should in any way think that the Speaker does not know what he is doing. He understands the game. He knows the rules. He knows the
standards. Says that he doesn't understand.
I'm coming, Honorable. I'm coming.
Nobody understands exactly what he's doing.
You see, the implicit assumptions, the implicit assumptions of the position of the minority, more or less, seeks to slay the speaker in some way. But the speaker knows what he's doing.
Exactly.
And much as I agree to the fact that the majority leader is the leader of government business in the House, so must we also realize.
In fact, he has been so properly designated.
Exactly. So must we also realize that power is vested in the speaker, though he's supposed to apply it in conformity with the law. So that power that is vested in the speaker exercises it as and when he feels he has to apply the powers. What are we talking about here? A member of parliament who was also a member of a previous parliament, and that previous parliament took a decision, and that member feels that after some years or some period, he wants to revise his thinking and his support for that particular decision. And therefore, he comes back to the House, which he is part of and was part of, that took a decision, and says, the House, this is my feelings about the decision we took. I want to table a motion for us to go back and look at that. And these are the issues I have against the decision we took. I'm not too sure about the sacrosanct and or irreversibility of a decision taken by a previous parliament. Because when I listen to Honorable Fuseni, he says that, oh, if it comes from the executive, and you rightly came in to say that, then in the case, the net effect is zero, as we're talking about. It can come from somewhere, and it will still be effectual. It will take effect. So the member comes to Parliament, and then tables the motion. The Speaker, in his wisdom, which I perfectly agree, the Speaker said, the matter you want to talk about, I am going to be restrictive in this case. I'm not going to allow you to go through the issues into details, but rather I will allow you to table the motion because of the sensitivity of the matter. And because of the fact that this appears almost to be the first time in our history under a form of Republican constitutional dispensation. This is the first time we are witnessing Parliament seeking to rescind a decision that has been taken by the previous Parliament. So this is not just an ordinary matter. It is not like all other matters that come to Parliament every day and we debate. This has some peculiar characteristics which we must respect in that regard.
Not even that it is being the first time, but it sounds like the first time we're having a private member seeking to invoke the powers of the Constitution allowing for private members' bail, which the Speaker says he will encourage.
Exactly. So this is a special case. So Speaker says, I'm not going to allow detailed discussion and debate on this matter, which may be, how we call it, prejudicial to what determination the committee would want to make. And it's in conformity, or as a standard practice in this House. I'm referring this matter to the committee responsible for this. And on that committee, minority and majority members are on the committee. It is not as if the committee is more or less tilted towards one side. There is an equitable. There is an equitable representation. If it is not equal, that is equitable in the sense that it comes from a proportion of how many majority members are in the Parliament. Okay. So there's some equity here. You understand? There's some equity here. So Speaker refers the matter to the committee, and you rightly ask the honourable member on the committee. You have the right to make your voices heard on the committee. So you go to the committee, you argue your case, you debate the matter. We all believe and think that our members of Parliament will work in our interest. And for that matter, we don't think that people will go there with their political coloration and then try to argue, not based on the interest of the people, but based on their political lineages. So that is what we respect you for. And don't create the impression, the minority should not create the impression that when matters are debated on the floor or at committee level, it is influenced by certain political motives. No. So when the matter is brought to the committee and the committee makes a decision, the committee's decision is then brought back to the House, the plenary level, where every member will then have an ample time to debate, as has been agreed by the leadership of the House. So at that point, Honorable Fuseni, if he's so designated by his side to debate on the matter for 20 minutes, he would have 20 minutes to debate the matter. The minority leader who is crying would have a chance to debate the matter. So it is not a matter that has been truncated and has brought to finality. This is a matter that the Speaker thinks that let's go about it this way. And I think the decision the Speaker took was fantastic in the first place. Because if he had allowed the matter to be discussed and argued on the floor of Parliament, chances are that there will be somebody associated with the matter
who is not a member of parliament, his name is mentioned, something is said about him, he doesn't have that right and the platform to be...
He's saying what they were intended to debate was the procedure. First, that the matter should not be admitted.
You see?
Because he was incompetent.
Okay, so that doesn't mean that once it goes to the committee, the movement from the House, the plenary to the committee, does not preclude any member of parliament to go and raise the issue of procedure at the committee level. So the committee, as per their decision, can come back and say, Mr. Speaker, the matter you referred to us, upon consulting the laws and the regulations of this House, we have realized that we do not have the capacity, or procedurally, it is wrong.
And
for
thankfully,
you to
something like that just happened with the special prosecutor's bill.
Exactly. So this is I don't know why we are crying.
But something, you are a lawyer, you know that if you go to court and the person on the other side has no capacity, and you don't raise the capacity issue in the initial stages, and you get to a point, you can't raise it again.
It's not the court. It's not
the procedures are almost the same there. The procedures are almost the same there.
This is not court. So something, I think there is no issue. I will plead with my colleagues. You see, the young people in this country would not want to witness such incidents in Parliament where we boycott Parliament, and some of the messages that came out from the minority side were also so harsh to the extent that some members said will make Parliament ungovernable and the Speaker is biased. I mean, we should try to protect the image of Parliament in that respect.
Before I bring you out in, I want you to tell us, the government says we can make savings of how much on this Ameri deal, and that's why it is intent on following this thing?
Yeah, you see, this Ameri deal issue became a topical issue when we were in opposition, and the position of this government, then in opposition, was that the deal more or less appears to have been through a Faustian manner. It is fraudulent, and so we ought to investigate this matter. And so coming into power, there was this mindset that this matter had to be investigated. That is why the Addison Committee had to be set up. They have done their work. They have submitted their report to the minister, and so I think at the executive level, government is going through. Now we have a member of parliament who comes to the floor and also raises an issue as an individual, a citizen of this country, and he's allowed to do so. And so that matter is also ongoing. I will leave what the executive wants to do to the executive. And at this point, I wouldn't be in a position to be able to tell what exactly is going on at the executive side and what they intend to do. But whatever each party, whether individual executive is going to do, I believe it to be in consonance with the laws of this country. And that is the respect we need to accord.
So what is going on now is not an executive act. It is K.T Hammond.
It is not.
Exactly.
It is not.
Okay.
Now, these ones can run concurrently. I believe so.
Yes. Now, I know you like to talk a lot of law, but and that is you. That's your training. What else can we do? And yes, you are seeing to students and teaching them law. What else can we expect? Now,
I speak for money too.
Yes, you do. Yeah, you do. But can the minority, having walked out on this process, go into the committee or participate in the debate when the document is brought back to the House?
Well, perhaps it's a partial walkout in respect of they being against the matter being debated in the House itself. But then its members are also bound to appear on a particular committee. But it may also then conflict with the concept of you can't approbate and reprobate. You understand? So that will have its own problem. But you see, I was shocked to hear some of the comments that some of the minority members made about the Speaker. Parliament belongs to members of Parliament, not the Speaker. Forgetting that the Speaker was elected. The Speaker is an elected officer of the state. We have fashioned out our constitution in such a way that when it comes to the Speaker, he doesn't have to contest an election with his name or picture on a ballot. But we are saying that he's deemed elected when members of Parliament elect him. The same way as the Vice President. He doesn't contest elections, but when he's taking the oath, I having been elected as Vice President, that is how we are fashioning out our constitution. In terms of precedence, the Speaker is number 3 in this country. And I can't imagine how a lawyer will appear in court and openly bang on the table because the judge has refused his application and call the judge, I will ensure that you are impeached.
That's unethical.
That is terrible. I don't think that in a setting where everybody is either listening or watching, our honorable people, with all due respect, if I had done it, I'm sure by now I had received my summons.
You can do it.
But why should a member of parliament...
Because you see, the speaker is elected by electoral college. And members of parliament constitute the electoral college for the purposes of electing
You voted on our behalf.
Yes.
So let me go on. Let me go on. You see, it is the responsibility of the speaker to determine which motions should even be brought to parliament. I think you made the point. Correct me if I'm wrong.
Is it the leadership or the speaker?
The speaker.
Okay.
That is the power given. So it is not an ordinary person. Even a judge doesn't have that power. Once a matter is filed, the judge has to look at it and hear it. Let me give you an example. The Ford saga. When the motion was brought, the speaker did not even allow the motion to be heard. He brought his ruling that very day and jettisoned it and said that as far as he's concerned, there is a matter before a constitutional body, SRAJ, and so this motion will not be heard. In that case, it wasn't even heard. In this case, the speaker is saying that, let me adopt another procedure allowed by law, or you say there is no such law, but he at least is going to listen to the person who has filed the motion and determine whether or not it is a matter that should be heard. And I agree totally with you. When Parliament had by resolution brought a matter into effect, like a contract, the rest is an executive act. Parliament cannot by itself seek to terminate the contract. And in Dibugri, rightly so, I think the minority leader made a bit of a mistake. In Dibugri case, the Supreme Court didn't say that it must be brought to court. It says it is an executive act. Yeah. In fact, this is what it says. It says, the context of the Constitution militates against the notion that Parliament must be resorted to in case of termination of parliamentary approved transaction. And that is an executive act. Yeah. That is very clear. But when it comes to annulment resulting from fraud or fraudulent act, it is the court.
Yeah.
So we need to even know whether what Mr. K.T. Hammond attempted to do was for termination of the contract, which is an executive act and only the executive can do, or he was saying that because the contract was tainted by fraud vitiates everything. Yeah. And so it is void ab initio, it never occurred. Yeah. That one you go to court for a determination. So I think if we can just draw the distinction. But you are fully right. Yeah. Parliament cannot generate a mechanism by which it will annul its own act of Parliament. It has to emanate from the executive. And so I think that we should not look at the Speaker as if he's a stranger in Parliament. The Speaker has been given powers to determine motions. In fact, whether it should even be brought again at all, and two, whether it should be heard in the first place and in what manner. If it is to be presented to the committee, and eventually the committee will bring the matter to Parliament, and the Parliament as a whole can even overrule, as you sometimes do, the committee, then what is the problem that we are raising? So that at that point, minority could have then raised the issue that the Supreme Court has already determined that a matter like this, one, if it's about termination, let the executive terminate it. But if it is about annulment, because it is void for non-compliance with, let's say, constitutional provision, as has been done in the Waterville cases and Vulcan Energy, the courts are the persons empowered with authority to annul such contract because they are inconsistent with law. So I think that a lot of people look up to members of Parliament. You have not earned the title honorable, even though sometimes abused, because it's something that I think you should be referred to only in Parliament. Honorable member of so and so. But you have acquiesced people calling you even in your villages. I'm sure maybe your wife may call you honorable.
Honorable sweetheart.
Yeah. But let the public, you see, and the discrimination against those of us who are not in Parliament. As I said, I had made this comment about the Speaker. It's not a near abuse, it is abuse. It is abuse. The Speaker was abused in this step. And this is one Speaker that for me, the few I have seen, he exhibits that paternal nature.
Most
speakers I have known.
It's not supposed to be paternal.
What I mean is that he's shown
paternalistic
not in the negative
relationship between members of parliament and the speaker.
Not in, and then somebody said that those behind us may be older than him, so he shouldn't treat us like his children. I mean, that is offensive, even to us. So please, going on. And for the leaders, and I think it's also because Parliament itself must have a legal unit where lawyers will examine this and advise Parliament. For me, I think the majority had it wrong in the first place by attempting to either cause this contract to be terminated or annulled, whichever way. But the solution is not by the way you acted.
Okay.
You could have walked out and state your position, but don't spew such offensive words against an elected speaker who you will call right now.
We elected him.
Right.
We elected him.
But yeah, what
this
do
is
you say?
We elected him.
I get you.
Yes.
On our behalf.
We will go on a break quickly and then return to deal with the mid-year review, budget review. But very quickly, I just wanted to find out from you what you make of the fact that there's been a lot leading to K.T. Hammond's attempt to rescind, this decision in Parliament. There's been a lot.
Yes.
I refer to the Addison Committee's work, which brought up a lot of argument, and some part of the work was disclosed to the public, suggesting that some fraud had taken place, and that there was a need to, as it were, renegotiate the contract or whatever it was. And then subsequently, these people being arrested, so to speak. They were invited, but please, their invitation is arrest.
Of course. At that time, liberty was restricted.
So don't you feel that they feel justified that there is a hunt, and this is just part of the plot, and they should not allow it?
And I say this with heavy heart. I mean, one of my best teachers is Dr. Ini, and I don't think anybody knows how to defend himself in law more than Dr. Ini himself. Interestingly, the next day, they all complied. They went to the police station. They gave their statement. So I don't think that was the right thing to influence Parliament or the minority to take that decision, because they didn't revolt. In fact, Dr. Kwabena Donkor said that the police were very competent in their dealings with him, and he had no problem. So I think the attempt to link it to these three persons is quite unfortunate. Let the law work. It's not as if, and I don't agree that we don't have strong institutions. We don't have strong men who will allow the strong institutions to work. And that is the problem. I mean, I sympathize with them, as I say, but they agree that they must comply with the law.
In the face of the Supreme Court's recent decision in the Standard Bank versus NIB.
That's right.
The suggestion he makes that Dr. Drosai raises that if they don't object now, they lose the opportunity forever. And when the matter concerns capacity, for example, are they right? Because the Supreme Court, I know that lawyers are debating that as bad law, the Supreme Court has done.
Honestly.
But that position clearly, I'm just reading portions of it right now. Position clearly is that even on appeal, Chachiketa went to raise capacity, and he won.
That is true, but then you see, a court, first of all, even with jurisdiction, the court must even determine whether it has jurisdiction to hear the matter. In the first place, nobody else can hear it. It is the speaker who determines which motion should be brought to the House. He has determined that. And it is also the law that where a court assumes jurisdiction, it can make a mistake, as it can also do what is right. When the court makes a mistake, the procedure is clear. So in this case, with all the problems, and I'm saying that the majority had it wrong in my understanding and in view of Ndibugri, but the procedure to cause that declaration to be made is not respectfully what the minority took, which was quite offensive. And so, yes, the speaker has the power to do what is right. But he may, in doing so, may also make mistakes. He's a human being.
All right,
the
so we take a break here.
Clear.
But before you come in what reaction you want to, may I ask you a question to bring your reaction so we go? Yeah. And if you can deal with that in 1 minute.
1 minute, yes.
In real terms, if the Ameri Act gets reversed, how does that affect the contract itself?
No contract. I mean, the city
and country
waste will be invoked. Yeah. I mean, we will pay for benefits conferred on us. Country merit. So that one, there's no case. Okay. I'm just saying that let's be clear on this matter.
Thank you.
With Opong,
yes, sir.
When we raised issues in Parliament, we were not raising those issues in relation to the 3 MPs who were arrested.
No, it was an answer to a question.
Okay, thank you. We take a break here. When we return, as I captured it, the finance minister went to Parliament and he says that government policies are yielding expected results. And I say, yielding expected results at a time the invisible forces threatening an onslaught over lack of jobs, because yielding expected result is jobs, isn't it? And they are threatening lack of jobs, despite assurances by the party that party faithful will be favored in job creation and openings. We'll be right back.